For this afternoon, we are going to look at question 2. So I will read that question and then we will listen to your response. The writ of habeas corpus is the most important single safeguard of personal liberty known to Anglo-American law. Do you agree or disagree with this conclusion reached by a constitutional scholar? Why or why not? Was President Lincoln justified in suspending the writ of habeas corpus during the Civil War? Why or why not? Why has Lincoln's decision to suspend the writ of habeas corpus remained his most controversial policy decision to this day? You may begin.
Chief Justice Hughes claimed, "It must never be forgotten that the writ of habeas corpus is the precious safeguard of liberty, and there is no higher duty than to maintain it unimpaired. Because habeas corpus is vital in the protection of liberties, fundamental rights such as those secured in the Bill of Rights, we agree that habeas corpus is the single most important safeguard of personal liberty."
Although the Bill of Rights protects personal liberties such as freedom of speech and a fair trial, habeas corpus is more significant because it requires the government to swiftly determine the legality of a person's imprisonment and allows other fundamental rights to be freely exercised. After all, what rights do we truly possess in prison cell?
As English Judge William Blackstone asserted, violating the rights to property or trial may convey the alarm of tyranny, but the confinement of the person where his sufferings are unknown is a more dangerous engine of arbitrary government.
Although habeas corpus can be suspended, as provided in Article 1, Section 9 of the Constitution, in cases of rebellion or invasion where the public safety may require it, the writ is only sparingly suspended, while many Bill of Rights protections are frequently restricted. In fact, none of the Bill of Rights freedoms are unlimited, as seen in First Amendment restrictions affirmed by Roth v. United States, where the Supreme Court ruled that obscenity was not constitutionally protected speech, and Second Amendment limitations affirmed by United States v. Miller, where the Supreme Court ruled that the government can restrict the types of arms people can carry. Therefore, because habeas corpus has a narrow scope for its suspension, as compared to the freedoms found in the Bill of Rights, it is the single most important safeguard of personal liberty.
Even though President Lincoln suspended the writ during the Civil War, his suspension was justified because his intent was to preserve the Union. In his 1861 message to Congress, President Lincoln categorized the war as a case of rebellion, in which the public safety requires the writ suspension. In fact, President Lincoln suspended the writ twice, first in 1861 and again in 1862. Attorney General Edward Bates defended Lincoln's decision, claiming when the very existence of the nation is assailed by a great and dangerous insurrection, the President has a lawful discretionary power to arrest and hold in custody persons known to have criminal intercourse with insurgents.
However, many opposed President Lincoln's decision. For example, Chief Justice Taney ruled in Ex parte Merryman that the President does not have the power to suspend the writ of habeas corpus because that power is found in Article 1 of the Constitution, which vests power to the legislature. Chief Justice Taney wrote, "President Lincoln certainly does not faithfully execute the laws if he takes upon himself legislative power by suspending the writ of habeas corpus and judicial power also by arresting and imprisoning a person without due process of law." President Lincoln instead found that the Constitution itself is silent as to who is to exercise the suspension.
Though President Lincoln made many controversials during the Civil War, including raising and financing an army without Congress, issuing the Emancipation Proclamation, and shutting down opposition newspapers, his decision to suspend habeas corpus remains his most controversial because it is still relevant to presidents today. In 2001, Congress enacted the Authorization for Use of Military Force Act, which permits the president to use all necessary force against anyone whom he determines aided in the terrorist attacks, empowering the Bush administration to hold enemy combatants in Guantanamo Bay without access to a judge or lawyer.
But in Hamdi v. Rumsfeld, Justice Sandra Day O'Connor wrote in her majority opinion that a citizen held in the United States as an enemy combatant must be given a meaningful opportunity to confess the factual basis before a neutral decision maker, once again demonstrating the vital importance of habeas corpus. We are now ready for your questions.
Thank you. As I understand it, your argument is that one of the major reasons for the importance of the writ of habeas corpus is that the government, we can quickly determine whether government has the right to incarcerate people. but don't we see a lot of the applications for writ for people who have been incarcerated for a while, prisoners filing for a writ of habeas corpus? So doesn't that suggest that's not how the writ's being used?
I think, yes, your statement is correct. We do see in Guantanamo Bay there are many prisoners who have not yet had a trial and haven't had the writ habeas corpus granted. And so I think that you're correct in saying that it isn't necessarily being implemented the way that our Constitution provides that it should be.
In addition, I'd also like to point out that the Supreme Court and the executive branch have been having a struggle with the judicial implementation, and there have been some misunderstandings with the rights of the detainees in Guantanamo Bay. In Hamdi v. Rumsfeld, the Supreme Court held that citizens held in Guantanamo Bay had the right to file for a writ of habeas corpus, and later the Supreme Court expanded this, saying that even if the detainee is not a citizen in Boumediene v. Bush, they still have the right to file the writ.
You mentioned in your opening that Lincoln was justified because he was doing this to preserve the Union. Can you think of any other reasons why a president would be justified in suspending the writ?
Well, I will also say that President Lincoln was justified because he did receive authorization from Congress. There was the Habeas Corpus Act that Congress enacted, I believe, in 1863, a year after Lincoln's second suspension, which basically just said that they approved both of his suspensions. And so I think that that kind of gave him some sort of authorization and kind of justified his decision. But I think other than preserving the Union, he was justified because he was acting as commander-in-chief. The first time he suspended habeas corpus was to protect Washington, D.C., and he was trying to make sure that the railroad that led to Washington, D.C. through Maryland, or there was a big path there, but he was trying to make sure that he could have the Union military succeed, and so he acted as commander-in-chief.
I agree with Sophie, and I believe that the Civil War was a very unique experience. So although we said in our opening statement that President Lincoln was justified because of the Civil War, I believe that other instances, such as holding suspected terrorists in Guantanamo Bay, that is not the same as what President Lincoln did, because it was more of an internal struggle. So I think that was a very unique experience, and if it's an internal struggle and the very existence of our nation is assailed, as we said in our opening statement, that is a reason to use to suspend the writ. However, I believe that that's a very narrow circumstance, and I do not advocate for willy-nilly almost suspensions.
So if it is a cornerstone, and if it is so important, and if it has such deep historical and constitutional roots, shouldn't we amend the Constitution to define more clearly when and when it couldn't happen? That today we're thinking that the events in Guantanamo don't justify it, but there seems to be time that there could. And shouldn't we amend the Constitution, because the last thing we need to be discussing in the time of war or rebellion is the niceties of constitutional law?
I think the reason that we haven't made an amendment on this issue is because it is a political question, and Congress is highly political, and so they're voted into office, and we find that we can still find a majority of the population wanting to be feeling more secure if suspected terrorists are still detained in Guantanamo Bay, even if they're detained without habeas corpus. And so there's hesitation from the legislature to initiate an amendment.
Yeah, as Claus stated, the amending process is so intense that without the popular support of the people, and there won't be the popular support of the state legislatures, who it requires with the 2/3 to amend the Constitution, but as Scott stated, without popular support, the legislature feels that they cannot pass an amendment as such, as you stated.
So this wouldn't be the kind of thing that you would get people just kind of jumping on the bandwagon? I mean, are you gonna be the state legislator that says, oh no, we don't wanna support the amendment to take terrorists off the street?
Yeah, I think that is a huge issue. I don't think that anyone is really willing to say, oh yeah, let's take all those terrorists out of Guantanamo Bay and give them all the protections in the Constitution. I think that that's just part of human nature. I also wanted to point out, going back to your question, that the Constitution, I think, is actually very specific as to when we can limit or suspend habeas corpus, because it is in rebellion, invasion, or where the public safety may require it.
Great, thank you.
You can breathe now.
Well, thank you. We very much enjoyed this conversation. I hope you did too. Best use of a citation to Justice Hughes, best use of the word willy-nilly in an appropriate way in a discussion.
He's from the South.
That's right.
He gives extra points on his exams in Clemson for the
That's
use of
right. It's a compound word.
Yeah.
Yeah, I really enjoyed it. It was a very clear presentation of where you stood. I thought you did a good job of outlining the criteria, talking about the narrow scope for suspension, and beyond that, just and a good use of all the way from Merriman to some good contemporary examples. More than that, one of the things we're always looking for, in addition to the historical and legal knowledge, are the kind of civic skills and dispositions. And it seemed to me that as a team, you clearly demonstrated those. And beyond that, if you're not planning an academic career, let me suggest one. I'm not sure your parents would be thrilled with that these days. But I saw some wonderful examples of taking the questions we asked and giving us the answer that you knew regardless of whether it fit the question that we asked. That is a wonderful talent to have. It got me a PhD. I see some future PhDs here if that's something you choose to pursue. So you did a very good job.
I agree, nice job. On your opening, I thought you had very good support, especially on the first thing, the threshold issue. I think you did a really nice job analyzing that and laying out the other parts of the question as well. I liked the it's so important, not just because of the specific right that it protects, but because it lays the foundation for all these other rights. And without it, these other rights don't mean anything. I mean, that's really important, and that was a nice way of explaining that. I also was interested in the point that this right is suspended much less frequently than other protections in the Bill of Rights are impaired. And I mean, you probably hear from your colleagues who are looking at some of those in their units how much case law there is and how often someone's trying to impair those rights. I thought that was very perceptive, very, very nice point. I agree on the follow-up. Every question I heard a good analysis of the end. You're really, it's clear that you have thought about some of these issues before, which is good, and that you are comfortable grappling with them and talking about both sides and thinking about, not just kind of the gut reaction, but based on the Constitution and some practical realities or political realities. That those things were really nicely woven in, along with some history woven in with the answers too. So very, very well done.
I'm third, so I'll just be repeating everything. So I'd like to just say you should have used the words carne asada, and that would have helped me understand what you said. You could have used pickaninny. So I just want you to know that I thought that you had really not just stated your opinions, but backed them up with facts and citations in a way that clearly conceived the ability to take an idea and manipulate it and work with the question in a way that you wanted to, which is important, that once you define the issue, you want to define it the way that you see it, and that